Well, we're in to do the discussions, and we told you about those two court outcomes of the cases involving a former chair as well as Director General and two others, and even a third, a fifth, who was subsequently acquitted of a transaction that was undertaken during the administration of John Dramani Mahama. We'll look at all these, including the Auditor General's contempt case. But look, let's start with this. And the Accra High Court has directed the Auditor or the Attorney General's office to seize properties worth some $3 million from former top officials of the National Communications Authority. Now, they have also been handed jail terms ranging from 6 years to 5 for causing financial loss to the state. Former NCA Board Chair Eugene Banfo-Boni, former Director General of the same institution, William Matthew TV, and a former Deputy Coordinator of the National Security were all found by the court to have been reckless and also acted with impunity in the purchase of cyber surveillance equipment worth $4 million. Joseph Akable was in court.
The case was the first corruption matter involving former government appointees that was filed by this administration. The Attorney General in 2018 accused 5 former government appointees of causing financial loss in the purchase of cyber surveillance equipment. The AG's office in 2018 accused 4 former government appointees and a businessman of causing financial loss in the purchase of cyber surveillance equipment. The office had alleged that this purchase was without the NCA Board's approval. The transaction was also said to have been outside the mandate of the NCA and was also not captured in its budget. An amount of $4 million is said to have been withdrawn from the accounts of the National Communications Authority, and $1 million out of this was deposited into the accounts of an Israeli company. The remaining $3 million, according to the state, was lodged in the account of a businessman, George Derek Opon, who acted as a representative of the local agents of the Israeli company, Infralux Development Limited. Mr. Opon was also charged with stealing but was acquitted and discharged by the court. Another accused person, Nana Ensau, was earlier discharged as the Court of Appeal overturned the submission of no case ruling by the court. The court, however, found former NCA Board Chairman Eugene Banfo-Boni guilty and handed him a 6-year jail term. Former DG of the NCA, William Matthew TV, was also found guilty and asked to serve 5 years in jail, while former Deputy National Security Coordinator, Alhaji Mimina Osman, also got a 5-year term.
Still in court, and Accra High Court, presided over by Justice Ifiasari Botwe, found the Auditor General Daniel Domelovo guilty of contempt. Now, the court also held that the reason given by the Auditor General that he was busy finishing up an audit report for Parliament, hence his failure to respond to an appeal seeking to set aside a surcharge, is untenable and an afterthought. Senior Minister Yao Safo-Mafo, in his application in court, asked that Mr. Domelovo be punished for failing to respond to his case, challenging a $1 million surcharge on him within 14 days. Again, Joseph Akable.
The senior minister filed a case in court asking that Mr. Domelovo be punished for failing to respond to his case, challenging a $1 million surcharge on him. His lawyers had asked the court to either impose a prison term or any appropriate sanctions against Mr. Domelovo. The Auditor General's office had insisted that Yao Safo-Mafo wrongfully caused $1 million to be paid a UK-based consultancy firm, Kroll & Associates, to undertake investigations on behalf of the government. He has pointed out that there was no valid contract between the UK company and the Ghana government when Kroll & Associates began work in 2017. Justice Botwe in a ruling said the law requiring that the Auditor General responds to appeals to his surcharge within 14 days is good law. She also stated that evidence before the court shows that Mr. Domelovo was properly served and his failure to respond was willful. Lawyer for the Auditor General Thaddeus Sori pleaded with the court to be lenient in sentencing the guilty Auditor General. Justice Botwe said the court notes the important role the Auditor General plays and doesn't want to discourage him. She, however, said his office is always late in responding to such appeals. She then opted to rather caution and discharge the Auditor General.
Now we have to do the discussions. I'm Mama V.
Well, absolutely. We've got two lawyers joining us via Zoom, but also to remind you that we've got a third issue, which is the Supreme Court's making a decision, the judgment on the eligibility of Martin Amidu. Remember, he's got a case about his age. That decision will be made today by the Supreme Court. But we've got Mr. Bernard Oredu Donko, who is a private legal practitioner. Also, Inusa Fuseni, he's a private legal practitioner, also a member of Parliament for Tamale Central and ranking member on Constitutional, Legal and Parliamentary Affairs Committee of Parliament. I want to say good morning to you. I think even before I could start, lost one of you, but good morning to
Bernard.
Okay, all right. Mr. Donko, good morning to you.
Good morning, Mama. How are you?
Very well, thank you, and I hope you're staying safe.
I'm staying safe. I'm observing all the protocols, and I have my nose mask with me wherever I go. Just that I'm alone in my office, that is why I'm not masked, but I always have it here around.
Absolutely. Great to know. So I want us to begin to, obviously, the High Courts got very busy yesterday, but the one that, I don't know if it was a surprise or if because of COVID-19, the attention wasn't really there until the judgment came. And this has to do with the NCA issue. On the surface of it, one would think, oh, it's the NPP that is prosecuting NDC, people who worked within the NDC administration, but there's also a real issue there. So let's start off. And Mr. Inusa Fuseni, you've also joined. Can I say hello to you? Hello, Mr. Fuseni? Okay, Alaji can't quite hear me, so we're going to work on that. But I'm still with you, Mr. Donko. I wanted us to set the tone. It's easy to look at it politically, but there's also a real issue underneath. But most importantly, there is a pending appeal with some of these gentlemen involved in this matter who have been convicted now. Can you explain in simple terms what has happened and what is also happening in terms of the appeal?
All right, thank you, Mamavi. I sat through court yesterday. I mean, for some of us who have been following, we were very much aware that the day for judgment was going to be yesterday. So early in the morning, some of us were in court, and I sat through almost 2 hours of legal hearing. And for me, there's nothing like political prosecution, because the judiciary is supposed to be independent of the executive and all the other arms of government. And that is why it is the state that prosecutes and not a political party. So prosecutions are not done in the name of a political party, but in the name of a state. Zooming in back to the case at hand, yes, I mean, there is a leg of it pending at the Court of Appeal. In simple terms, every accused person, after the prosecution leads evidence in prosecuting you, you have the right to go to court and say that, court, listen, all this evidence led against me cannot sustain the charges against me, and therefore allow me to go discharge and acquit me. If the court finds so that the evidence led by the prosecution, there's no case for you to answer, the court can discharge and acquit you. So in the case of the NCA, some of the 3 members, they have a pending application, which is an appeal on the submission of no case ruled by the trial court judge pending at the Court of Appeal. But let me be quick to add that it did not technically and necessarily stay in the hands of the High Court judge to go about whatever he was supposed to do. The accused persons have the right to pursue that as well and hope probably for a good outcome for them. So basically, yes, there's a pendency of an appeal on the submission of no case at the Court of Appeal, but yet did not technically operate at a stay to hold the hands of the trial court judge to go about his business yesterday.
It is important to also mention that there was one person who had been, who went to the Court of Appeal and
yes,
who,
yes.
So who was not included in this because he was also fighting off the same charges in terms of...
He had been discharged earlier.
By the Court of Appeal.
By the Court of Appeal on this same submission of no case. So he was not even part of those who appeared before the court yesterday.
Great. There was a 4th person. We'll talk about him, but let me check if I have Mr. Fuseni joining us and if he can hear us, if we can also hear him. Mr. Fuseni, good morning again. Good morning, Mr. Fuseni. I can see you, but I can't hear you.
He's not speaking.
No, he's not speaking. So let me still stay with you. Let me stay with you. And I want us to...
He looks interested. I mean, he really wants to say something. If you could really try and get you to him.
Absolutely, we will. So whilst my producer does that off air, let me let you, Mr. Donko, explain the issues in very simple terms, because there is a businessman and there's also an Israeli company that we purchased an equipment from. We paid $1 million, and I want to deal with it this way. So we paid $1 million, but that was part payments of the equipment that we purchased. Why are we dealing with three people, one a former board chair of the NCA, another the director general, and then a security person, when there was a businessman in the middle of this? And the state alleges that the businessman distributed monies from this sale or this purchase of this equipment, and it was only one of them, which is the former board chair, that there was evidence, because he had made some confessions himself of about $200,000, but we didn't see any trail of that distribution, if you like, with the others. Explain why these three are paying for something that there's no evidence that they actually got some of these monies.
You see, as for the no evidence part, you know, the prosecution led a lot of evidence in establishing the guilt of the accused person. So that is what the judge considered, and I mean, gave the ruling, his judgment yesterday. But you see, let me explain in simple terms the offense of causing financial loss to the state. You see, for instance, the businessman is not the state actor. It has a lot to do with state actors and very little to do with non-state actors. So the businessman was just a businessman somewhere who is doing his usual business. But it was the responsibility of those acting for and on behalf of the state to ensure that in dealing with the businessman, the state does not incur any loss. So for instance, you sell a pen for, let's say, 2 cedis. On the market, we know that probably the pen is 1 cedi. If, for instance, a state actor, somebody acting for and on behalf of the state, fails to do due diligence, fails to do all the necessary checks, and shows out the 2 cedis to you, you would definitely know that the money came from the state coffers, and therefore, if there should be somebody who should be charged for causing financial loss to the state, it is the person who was supposed to act for and on behalf of the state, because such a person is in a fiduciary relationship. The state, me and you, everybody has reposed so much trust in his judgment, so much trust in his decision, that whatever decision he takes or whatever decision he's supposed to take is supposed to inure to the benefit of the state and not personal profit. So that is the whole issue about the causing financial loss to the state. It is a consensus of with state actors more, people who are supposed to act for and on behalf of the state.
Let's see if we can have Mr. Fuseni join us now. Mr. Fuseni, another good morning to you. Hello, Alaji.
Good morning, Senior Fuseni.
Okay, that's still not quite working. That's technology there, but we're still working on it. We're not giving up.
I would have been interested
to hear from him. Absolutely. If Zoom is not working for Mr. Fuseni, let's translate that into a telephone conversation. It would still be good. Mr. Donko, there's an issue of a board chair approving, and I'm doing it this way because I want us to all understand, because of the way that it has appeared, it's easy to lose all the tiny bits of information embedded in this whole judgment, so that in the end, I want us to also talk about what is there to learn going forward. So we're talking about a board chair who approved a figure without, but this is a board chair, but that's not the entire board. Explain what went on there in terms of the approval of this $4 million.
You see, the decision of the judgment is quite comprehensive, and because there are, issues that may come up on appeal, I wouldn't want to so much go into it, and also because I'm not a lawyer in the matter, I cannot behave as if I am seized with all the facts. What I listened to the judge say is that there was more responsibilities on the three other persons, the director, the Mr. Tevi, and Mr. Osman, because you see, they are the managers of the day at NCA. So such decisions, they were supposed to have done sort of more due diligence. But I wouldn't want to say that there was no evidence linking the director. All I could say is what the courts have said. He was discharged by the Court of Appeal, saying that there was no case made against him. If we should go into it by probably linking him up and bringing evidence, it will be as if we are questioning the decision of the Court of Appeal. But the Attorney General, the state has not appealed that decision. And as we speak right now, the man stands a free man. So going into the nitty-gritty, what might actually happen, it remains our individual judgment. But now the Court of Appeal has spoken that the man is free to go. He had no case to answer at the trial court.
All right, Mr. Hussein is joining us via phone now, so I guess we can hear him. Alaji, good morning again.
Good morning, Moavi. How are you?
Very well, thank you. We could see you, we couldn't hear you, but at least we've seen you, so hearing you alone is fine.
Thank you, thank you.
All right, so we've been talking, I don't know how much of it you heard, because you looked like you could hear us. So if there's...
Well, I could see your mouth moving, but I could hear no sound.
Okay, all right, great. So we're talking about the matter of the NCA, the conviction that came in yesterday. Any initial comments that you want to make on that subject?
Well, initially, my initial comments are that, well, it's a sad case for the board chairman and the three other persons or two other persons who have been convicted of the offense of causing financial loss to the state. The judgment of the court is not yet ready. When the judgment is ready, there will be an in-depth study of the judgment, and probably appeals will be filed where necessary. But I think that it's really a sad day for them. In fact, we will look at the judgment. I mean, from what the excerpts we have read, it doesn't appear to us that the machine was not bought. The machine was bought. So what was the law? The law was the law the fact that the machine could not be installed, or what was the law? Or the machine could not be installed at the time that it was supposed to be installed.
Does it matter?
Was it the cost of the machine? So what is the loss? I mean, when the judgment comes, we will understand the nitty-gritty or the thinking of the judge in holding them responsible for cost of financial loss.
Well, at least with the excerpts that came out, not the full judgment though, we do know that we paid the 1 million to that Israeli company, and that was supposed to be part payments. They came to pick up the equipment because we had not paid in full. So,
yes, so
we spent.
So that is, again, what were the terms of payment? Were we to pay $1 million as advance payment for the delivery of the machine? When was the payment for the rest of the money to be made? All this might be captured in the judgment, and we will want to see why the Israeli company came back for the machine, because we had paid only $1 million.
It is also crucial, Mr. Husseini, to note that there was a confession statement that the court heavily relied on.
Well, I've already, I followed the proceedings, and I know that the confession statement was impugned.
But going forward, I mean, what does this teach us about? We've talked about corruption. We've talked about people being punished for acts that, you know, they did. This certainly, even though in terms of the court convicting the personalities, you would say is sad, but underneath it, this is a court that is working because some people, per the court's own decision, did not do due diligence.
You see, equality of treatment and universality of application is important for securing the ends of justice. And regime change accountability is not the best to hold people accountable for or responsible for acts of commission or omission while in office. And that is what introduces partisanship into the whole debate of whether or not we are fighting corruption. And I had always believed that governments should be able to hold their appointees accountable as much as they hold the members or officers or appointees of a previous government accountable. And insofar as government is applying different treatment to almost the same situation, then you cannot help but look at what is happening through partisan lenses.
But Mr. Hussaini, apologies there to cut you, but this was a court's decision. It wasn't a government decision, was it?
Well, the judicial prosecution starts with a complaint and the investigation of the complaint and the establishment of a prima facie case that an offense has been committed before the matter is sent to court. Okay? And so the decision to pick and choose a case has political undertone. And that's what I mean.
But
I'm not meaning the court. I'm not accusing the court in any way of being politically biased. I'm saying that the decision, the universality of application, that look, in the same matter, under the current regime, might not see the court. The exercise of the discretion of the executive in similar circumstances of their officers might not end up in court.
Mr. Hussaini, I was speaking to you strictly as a lawyer this morning, but just because you've gone there, I just want to ask, is that surprising? You're a politician.
Well, I'm a lawyer before a politician. And I know the ends of law is to regulate the affairs of persons in society. And criminal justice must actually secure justice. In no way should a decision of a court or the treatment of persons accused of the commission of a crime be tainted with political coloration. And that is my worry. And I worry because as a politician, I could have been standing in the dock. And it doesn't matter whether I acted in good faith. The state would to get me incarcerated. That is my worry, that's my fear. And that is what I've expressed.
There's another leg of this, and I want to begin with you, Mr. Donko, because you're still with us on Zoom, I presume. Normally when this happens, it would be, so we've convicted, people are going to jail, and the money is gone. But in this case, the judge also ordered for the confiscation of their assets.
Yes.
And that's a game changer, isn't it?
Yes, of course. I mean, if I could just react briefly to what Senior Nusa said. You know, some of the times we might want to believe that some prosecutions are probably have political undertones, but definitely it would have to take the discretion of the Attorney General to initiate a prosecution against any individual. But the question is whether the individual had a fair trial. I have been following this particular case, and I'm very much convinced, even as yesterday when I sat through court, that the judge was very much convinced in what he wanted to do in his decision. So for me, I believe that, like Senior Nusa is very much aware that the judgment is not the end of the matter. They have the right to appeal all the way to the Supreme Court. So let us hope and believe that the judiciary would act or seem to act independent of any other external influence. Back to your question, Mamavi, I believe that it was a good initiative because the judge added that assets belonging to them worth $3 million should be seized. It is high time we fight corruption in such a manner because people have often shared the view that, oh, if I could amass this amount of money and go back, go to jail and come back to enjoy it, then it would be rather an incentive. Because at the end of the day, if I have the money, if I have all the resources, I could be taken care of whilst I'm in incarceration. So if I'm back and could have access to all the largesse, all the wealth I amass, then it could rather be a sort of a motivation for people to go into corruption. But in this case, losing whatever you have I mean, as a result of your involvement in a matter which has resulted in you being incarcerated, will be a major disincentive and will be a major boost for the fight against corruption.
So a question on the back of that, is this fair punishment considering they're spending time in jail and also paying off the money?
As to what is fair or unfair, you know, judicial decisions are in themselves discretionary. I mean, the judge looks at the evidence adduced before him, he looks at the situation. In fact, in reading the judgment, I was in court yesterday, the judge alluded to the fact that corruption has become endemic in our system and we should have some of these cases as examples. He even also bemoaned the fact that by the rules of court and by the system we have in court, we should be able to shorten this trial, because he mentioned that the trial had taken close to 2.5 years, and that was in itself a disincentive in the fight against corruption. So for me, as to whether it is fair or not, the trial court decision is not conclusive. They have the right to appeal. The Court of Appeal could overturn the decision. The Supreme Court could say even otherwise. So we leave it to the judicial system. We leave it to the rules of justice, but we'll be monitoring it closely.
Mr. Fuseni, I want to ask you the same question, considering we're confiscating their assets, the court's directing exactly how this should be done, and also jailing them, the two going together. Would that amount to fair punishments in your personal views?
That is what criminal justice is intended to achieve, that nobody benefits from the process of a criminal enterprise. So if they have been convicted, the next order, or the most appropriate order the court will give, is for them to return, or for the state to confiscate the unjust enrichment, the proceeds of the crime. And so I don't have a problem with that. I have a problem with the processes, and where justice is seen to be done, it must be manifestly seen to be done. Now, Donko talks about he followed the process. In one of the cases, Dr. Esiao, the Court of Appeal was of the view that the trial judge was employing gymnastics to come to a conclusion that monies found in the account of Dr. Esau were monies derived and obtained from the commission of the crime, to which the distribution of monies that had been given to them by virtue of the monies that they had collected from the NCA. When there was no direct inferential evidence to link the money in the account of Dr. Gishao to the commission of the crime. And so you see, and so his submission of no case was upheld on appeal, and he was acquitted and discharged. So we have to wait until we see the judgment. The overzealousness of some judges to convict might be the undoing in this case.
And well, this is Roland here, and I have some bit part to play as well. So I have just two questions. And if you look at the summary of what was given to us yesterday, you also get to find that the judge feels that we can improve jurisprudence by this case. And she says that for pre-trial disclosures and inspections that emanated from this case, as decided by the Supreme Court, to my mind calls for an urgent need for a complete overhaul of both Act 29 and Act 30. As the Supreme Court makes the procedure and Act 30 now anachronistic. Now, if you move forward, it also says that subsequently, there are a lot of interlocutory injunctions and subsequently also seem to have a lot of truncation and inhibitions in the way of just a normal case. How, I start with you, Mr. Oredu Donko, how can we use this case in point to say, look, let's just go straight to the point and not go about beating around the bush, which you lawyers tend to use for your clients subsequently?
Well, let me start by first saying that I strongly did not share the opinion of the judge when he talked about lawyers filing applications, interlocutory applications and all that. This is a matter of sentencing and freedom. The freedom of the individual is at stake here. If it is found guilty, it could go with custodial sentence. So lawyers will employ every legal available tool to defend and vindicate the rights of their clients. So if it is under the ambit of the rules of court and law only it is allowed by law, I don't think we could fault lawyers for going with applications before the Supreme Court, before the Court of Appeal, before the trial judge, just to protect the interest and freedom of their clients. This case is epic in the sense that at least when it comes to disclosures, now at least we have a directive from the Supreme Court as to how criminal prosecution should go about disclosures. Initially, before this particular case, we never had that. So at least this case has given us the opportunity to enrich, to expand the frontiers of our criminal jurisprudence. But indeed, lawyers should be allowed to operate within the ambit of the law, unless clearly it is an abuse of the judicial process. So for me, I sat through court, I listened to him, but I did not share that opinion that he was bemoaning the fact that the case had been fraught with a lot of applications coming from defense counsel. That is very much expected, because you don't expect defense counsel to just sit through, because at the end of the day, if the client is convicted, he may go to jail. So if a defense counsel is employing every available legal tool in defense of his client, I think what the judges would have to do is to bear with us. After all, we say the rules of justice, it grinds slowly, but it grinds perfectly. So for me, I believe that there should be no shortcut for criminal prosecution, and every person should have his day in court. Every person should be given the best legal assistance, the best legal representation, even if it takes 2 years to secure a correct conviction. It is better than using 6 months, 3 months to go get somebody wrongly in jail. So me, I don't share in that view at all. Lawyers should be allowed to operate, and in operating, they should be allowed to file the appeals they deem appropriate and necessary in defense of their clients.
All right. Then the second one. Mr. Inusa, you have anything to say to this, or I can ask my second question?
Well, I think that I share in his view. It's a right issue. In a criminal trial, the duty or responsibility of the accused person is to raise doubt. And in raising doubt, he has to employ all the legal tools available to him.
Yeah.
Mind you, if the accused person is convicted, he loses his rights, especially the freedom of movement. He's going to be incarcerated for a number of years. He loses support of family because the family will no longer have access to him. There are many things that he will forgo. He is not entitled to a good name because he has been convicted for a crime. And so these are very weighty matters that has to be taken into consideration by any defense lawyer. That a criminal prosecution, a criminal trial, is not just a trial. It's a trial that involves the life and dignity of a person.
Now, in 2016, we had Mr. Chikata organize a press conference. In this, you go into the archives, you can well find. And he was really concerned about the application of the law on causing financial loss to the state. Now, he said on that day, in that press conference, and I was there, he said the law is archaic and was not in tune with the times. And we know this is a matter of controversy. Let me start with you, Mr. Inusa, on this related application.
I totally agree with Chikata, Chachi Chikata. I was part of the counsel in the quality grain case, and I was left in no doubt at that time that the law is bad law. I am still in no doubt that that law is bad law. But because it has now been weaponized, it is difficult for any political party to bring an amendment or a motion or a bill to have it repealed, because it is now weaponized. Political parties and governments use it against their political opponents, and that is the difficulty.
Mr. Uredu Donko.
Well, I wouldn't share in the view of Mr. Inusa that is bad law. What I've realized about the financial law is that it's so broad, and it gives the prosecution and the judge a lot of room to operate. In that, all that they would have to come to court to say that
a bad law gives the judge a lot of room to operate. Criminal jurisprudence should be construed strictly.
Yes, it gives. Yes, I would admit that it gives the prosecution and the judge a lot of room to operate. But then again, I'll be quick to add that the person who is accused of causing financial loss to the state is giving the opportunity to defend his case, to vindicate his right. So for me, I don't think that there's bad law to the extent that there are some state actors who deliberately or per negligence cause some loss to the state. And such people should not be made to go.
This is a law on the statute book. Tell me one case in which a person has been charged with causing financial loss and has been acquitted and discharged by the court.
well,
I do appreciate your concern because almost
that is
from
the
quality grain case all through to Mr. Chikata. But to say that it's been weaponized is quite extreme, which I don't share. Because, for instance, if you haven't caused financial loss to the state, there's no way you could be caught in this work. So at least we should maintain such laws to at least deter people who are state actors that at the end of the day, you have this law of financial loss to the state. So whatever act, whatever situation, in whatever thing I do, in performing my duty for and on behalf of the state, I should have some mindset of this law waiting for me. But my only reservation is that it's too broad, and it gives the judge and the prosecution a lot of room to operate.
What is interesting?
Come back to the same position.
But what is interesting?
Criminal legislation must be construed strictly and tightly.
Mr. Hussaini, I think what is interesting is the fact that this only comes up when a government uses it against persons in a previous government. But yes, but you come and the law is there, you don't do anything about it.
Because it's not weaponized. Even I will not suggest that it should be repealed. Because my party will win power.
So you come and use the same weapon against your opponents.
It's a weapon.
This is interesting. But
that becomes
because you see, when you look at the case, when you look at the history of cases, look at even Chikata's case. He had to be convicted, and sentenced. He served part of his sentence before the Court of Appeal ruled that the trial judge was wrong in refusing to invite the international body to give evidence. After he had been convicted.
All right, gentlemen, because we have two other issues tabled, we will touch on them briefly. I know this has taken a greater part of the time, appropriately so, because this was a huge conviction. And so we needed to spend time on. But let's move away from Justice Eric Chebafor's court now. And let's talk about this other one, Justice Sewa Boche's courts on this ruling, this contempt case against Mr. Domolovo. Not getting a custodial sentence, but this is also punishment in itself. What does it say in terms of procedure, doing the right thing? And I'll start with you, Mr. Donko.
Well, for me, I think that people should not disregard court procedures and the requirements or what the dictates of orders of courts require a person to do. Because you see, I always tell people that the last hope and the last resort is the judiciary. So if we don't respect rules of court, if we have so much disregard for what court asks us to do, then it's dangerous for all of us. Because you see, the point is that once you subject yourself to judicial processes, you should be ready and available for all the requirements that comes with it. So for me, I think that state actors, individuals should respect the court. Because if we have a judiciary which is not functioning, if we have a judiciary which is not biting enough, if we have a judiciary that people can just disregard them, it is not good for all of us. Because for me, the judiciary is the last hope for every nation.
Mr. Hussaini, I just wanted to ask, still on this issue, if the Mr. Domolovo's office is obviously very busy, why is the Attorney General not taking up issues on that office's behalf, if you like?
Well, Domolovo has been sued in his personal capacity, okay, as Auditor General, and then is a constitutional creation, and because of that, the decision in the Electoral Commission case, you remember, where they said that because they are independent constitutional bodies, they should have legal counsel representing them other than the Attorney General's office. And so that's the constitutional creation. The office is a constitutional creation, and that is why the Attorney General probably is not minded to step into the matter.
Because I was just
to be controlling and directing the affairs of the audit service contrary to the provisions of the Constitution.
Because I was just wondering how he would miss the fact that he had 14 days within which to file a piece of documents, and he missed that.
He would just have to instruct his lawyers. He doesn't need to go to court to file those documents. He instructs his lawyers. And I'm sure because of the contempt proceedings brought against him, the lawyers would have been preparing the documents to file same. And I should think that Mr. Domelevo will be well advised to file them within the 14 days.
Well, I pray that our attention is not only on the contempt case, but we also are mindful that there is a substantial case. And for me, that is what is most important.
The contempt case is important for us to understand that it establishes the principle that no one is above the law.
Absolutely. Okay.
Yes. So for us, the court had extended some degree of respectability to the office of the Attorney General when he said that, well, it was in contempt, but he should go and sin no more. That's a conviction, you know that. And a caution is a conviction. But then he was not incarcerated in the view of the court. So clearly, the signal has been sent that nobody, unless the law makes it, like in the case of the president, the law makes it mandatory that there is a prohibition against bringing the president to court while in office. But no one in this country is above the law. But
in terms of the punishment that came with it and the explanation that the judge gave, what do you make of that?
Well, I think that is good. It's a right signal that, look, you have duty to the court and you cannot hold the court in contempt, no matter how busy you are, no matter how important your office is, that you must always answer to the invitation of the court, and you must abide by and try to live up to your responsibilities in ensuring that you file the necessary processes in court to ensure an expeditious trial in the matter in which you are involved. So I think it's a good principle that the court has established.
Yeah, Mr. Donko, you want to say something? Yes, sir. Go ahead, please.
Let's also use this opportunity to commend some of our judges. I mean, there have been a lot of times where most of them have come under criticism and bashing, where they also deserve some commendations. I think we should give it to them, because this is a whole Auditor General. I mean, a very big state actor, a very big office, a constitutional office, and Mr. Domelevo in himself is a huge stature. So for a High Court judge to have gone the way she did, I think that it means that there is hope in this country, there is hope in the judiciary, and we can say that once the judiciary will be acting in such manners, then at least we could all have a very good day in court. So I would want to commend the High Court judge for taking such an initiative. It has often happened so many times that it has been swept under the carpet. Nobody talks about it. So for the High Court judge sitting to actually convict an Auditor General in the stature of Domelevo, then it means it's something we should commend.
Appropriately so. Justice Efia Asare Boche, always doing such a great job, comes across as a very diligent, fearless personality as well. But I also want us to, before we end, one more issue. All eyes on the Supreme Court today on that ruling on Amidu's eligibility as special prosecutor. What are your expectations, Mr. Fuseni, first? Well,
it is an interesting day. We are waiting to see what the legal gymnastics the Supreme Court will use to analyze the case, because clearly Martin Amidu's office, the public office, was established pursuant to the Article 195 of the Constitution. Martin Amidu is a public officer. The Constitution provides for the age limit for a person to occupy public office. Martin Amidu was not given a contract. He was appointed as a public officer when he was 60 years old. So we want to see what will be the outcome.
Mr. Redonko?
Yes, the Supreme Court's decisions are often motivated by personal philosophies and personal beliefs. So looking at what I'm hearing, it's going to be an interesting judgment, because it will have a telling effect on the appointment of
Please, what are you hearing?
Oh, what I'm hearing concerning the panel is a mixed panel with different philosophies. The Supreme Court decisions are often motivated by personal philosophies and personal beliefs. So looking at what I'm hearing, it's going to be an interesting journey because it will have a telling effect on the appointment of
what are you hearing? Okay, we obviously have issues with this technology, and within that, have I lost you, Mr. Donko?
Are you talking to me,
in video, but not in audio.
Okay, yeah. Mr. Husseini, not to you. Mr. Donko, quickly wrap up on that submission for me.
Well, I'm saying that it's going to be interesting because its effect is enormous, because it's going to affect the appointment of government going forward. And for some of us who are young and believe that at a point in time, the young should be looked at, we are looking forward to this decision of the Supreme Court. Okay,
great. And we can't wrap up without talking about two great lawyers who also appeared before the vetting committee of Parliament. Got everybody, well, they got very positive reviews, even from us ordinary Ghanaians. And obviously, members on that committee were also impressed, so they approved. Mr. Husseini, this report will come to the plenary.
Yes. There is a notice inviting us to Parliament on the 19th of May. I believe that if, barring any last-minute hitch, if we are able to go to Parliament on the 19th, I'm quite sure the report will be laid in Parliament, and probably the next day or the day after we will take the report. But clearly, Mensa Bonsu, Herita Mensa Bonsu, my own lecturer, professor, was in a class of her own. I've always known that she will be in a class of her own. I mean, she was nominated to serve at the International Apex Court, and somehow she didn't get the required nomination. And she distinguished herself. You could see the law in her flowing at will without effort. I think that when I'm given the opportunity to talk and contribute to the report, clearly, I will pay my tribute to Herita Mensah. She taught me, and I have always had no doubt whatsoever in her capabilities as a good lawyer, as a lecturer, law lecturer, and now as a Supreme Court judge nominee.
You know, Mr. Donko talked about philosophies. When you look at the two, Professor Henrietta Mensah and Yoni, what would you say they represent? What are they bringing to the Supreme Courts?
But Yoni and Professor Mensah are not comparable. They are not. And I don't know why you are seeking to compare the two.
No, I'm not comparing. I'm just saying as individuals going onto the Supreme Court, what do they bring?
Well, Professor Mensah, from my assessment of her, is a realist.
Okay.
So she will talk to the issue, she will approach the issue as it should be approached.
Okay. All right.
And I believe that she will carry that onto the Supreme Court. And she's not afraid. I repeat, Professor Mensah is not afraid to talk her mind.
All right. Thank you, Mr. Inusaf Husseini. Just your final words in terms of their philosophies, and what do you think the approach would be for these two?
Yes, I talked about philosophies, and with the two is an interesting mess. I mean, one is coming from the academia with a huge experience. I mean, I could say that she could be a teacher to over 60% of practicing lawyers right now. And so you know that, I mean, most of us know her, we know her tendencies and all that as a teacher. But as a judge, probably we are yet to know her. But we believe that just as she's excelled academically, she'll bring that excellence to the bench, because they say excellence cuts across. Mr. Yoni, some of us look up to him as a very experienced legal practitioner. And that is why I say that they come with a different mix. One with a huge baggage of legal work, and one with academic work. And it will really enrich our Supreme Court. We only hope that opportunities will come for them to let us feel their philosophies on the Supreme Court bench.
All right, gentlemen, thank you so very much for your time this morning. Thank you for breaking the issues down for us as well. Stay with us. We've got 2 more conversations coming up right here on the AM show. We've got Akese Brimpong joining us as well. But time now for our fake news project story for today. Our focus is on whether COVID-19 can be transmitted through sex or kissing. Virologist at the University of Ghana Medical School, Reverend Professor Kwamina Sego, has been reacting to this.